From KVUE News in Austin, you're watching Texas This Week with Ashley Goodo.
Good Sunday morning. Texas emergency rooms cannot be required to perform life-saving abortions. That ruling came down from a federal appeals court this week. We're breaking down the ruling, but first, here are the 3 things you need to know in Texas politics. The family of trailblazing Congresswoman Eddie Bernice Johnson is preparing to take legal action over her death, saying the former Congresswoman died a, quote, terrible, painful death last weekend due to medical negligence. While receiving rehab treatment from the Baylor Scott & White Institute for Rehabilitation after a September back surgery, Johnson's son says he found his mother lying in her own feces and urine, leading to an infection that then required another surgery. Johnson's family says she died from a spinal infection while in home hospice care on New Year's Eve. The family's attorney sent a pre-suit notice to hospital officials giving them 60 days to resolve their claim. If it isn't resolved, a lawsuit will be filed. Scott and White leaders say they are committed to working with the Congresswoman's family. The U.S. Department of Justice is suing Texas over a new law allowing police to arrest migrants who they believe have entered Texas illegally. Lawmakers passed Senate Bill 4 in the 4th special session last year to address border security, as Governor Greg Abbott argues not enough is being done on the federal level. It's set to go into effect March 5th, but the DOJ calls the law unconstitutional, noting enforcing immigration law is a federal responsibility. 30 new Texas laws went into effect this week, perhaps most notably Senate Bill 17, banning public universities from having diversity, equity, and inclusion offices, officers, employees, or contractors. Supporters of the law claim DEI initiatives are polarizing, while university employees argue the offices are used to recruit diverse students and staff from underserved communities. This week, a federal appeals court ruled Texas emergency rooms cannot be required to perform life-saving abortions under the Emergency Medical Treatment and Labor Act. The Biden administration issued that guidance to emergency rooms shortly after Roe v. Wade was overturned and the state of Texas sued. Eleanor Klibanoff, women's health reporter for the Texas Tribune, joined me to talk about what the ruling means. Let's start with the ruling from the 5th Circuit Court of Appeals. Tell us what it says.
So the ruling basically upholds a federal district judge's ruling that said, that while physicians in emergency rooms in Texas can perform life-saving abortions, as they comply with state law, they cannot be required to perform those abortions under federal regulations. The Biden administration has said that this is just a restating of obligations that already existed before Roe v. Wade was overturned. Texas, has claimed that it was trying to turn emergency rooms into sort of a workaround to the state's ban on abortion. And the federal appeals court sided with Texas.
And so let's dive into a little bit more about the reasoning behind this. The U.S. Department of Health and Human Services actually issued that guidance back in June 2022. Tell us more about their reasoning about why they felt this was needed.
Right. So after the overturn of Roe v. Wade, when states like Texas started to pass these abortion bans, the Biden administration took several steps to try to shore up abortion access and basically say, your state laws are your state laws, but under federal regulations, we do have some control over what hospitals do or don't do. And one of the things hospitals must do is stabilize and treat patients who show up at their emergency rooms. This was originally a regulation intended to prevent patient dumping, say, we don't want to treat you, or if a woman shows up in active labor, transferring her because she couldn't afford to pay for treatment. So this, they said, part of stabilizing treatment can sometimes include performing a life-saving abortion. And, that's part of your obligation as a hospital. And we want to remind you of that.
Now, the state of Texas, under the abortion law, has a clause that says if the life of a patient, if the life of a woman is at risk, doctors can perform abortion. So why do you think the state disagreed with that guidance from the federal government?
Right. Well, as we've seen, in the last, year and a half, doctors are very confused about how to implement that exception that says, you can perform an abortion to save the life of the pregnant patient. And the stakes are so high. I mean, a doctor who is found to have performed a prohibited abortion can face up to life in prison. So what we've heard repeatedly is, doctors delaying or denying abortion care. And, the federal government is basically saying your state laws, being what they are, we just want to remind you of your obligations under federal regulations as well. And Texas felt like that was an overstep and sort of a way of expanding that medical exception further than state law would have allowed.
So do we have reason to believe, or have you heard of cases where Texas women are showing up to emergency rooms, really on the brink of death and then being denied abortions? Is this happening?
Certainly, we've heard many stories like that. The ongoing lawsuit in state court, Zorowski v. Texas, is up to, almost 24 plaintiffs of women who have come forward to say they were delayed or denied, what they say were medically necessary abortions. Just at the end of the year, we had the case of Kate Cox, who went to an emergency room 4 times for a non-viable pregnancy. And her doctors basically said that under state law, there was nothing they could do to help her by performing an abortion.
And so, again, we're still waiting on some guidance in that case, right? The Zorowski versus Texas, the first one you mentioned, still waiting on a ruling on that.
We're still waiting on a ruling from that. The Supreme Court in the Kate Cox case sort of tipped their hand and said that they think the Texas Medical Board should be issuing more guidance. The Texas Medical Board has said they would like to see the Supreme Court issue their ruling in Zorowski v. Texas first. So we are at a bit of a standstill in terms of getting doctors the guidance that they say they need. And, we should say that this case that we're discussing today about the, what emergency rooms can be required to do, we have not heard yet whether they plan to appeal that, but that could potentially go to the U.S. Supreme Court. So these issues are far from resolved.
The Texas Supreme Court is expected to issue an opinion in the Zorowski v. Texas case in the coming months. That's Texas This Week.